When thinking about how to secure your family's future in Dubai, two options usually come up: setting up a trust or writing a will. Both are legal instruments for passing on your assets, but they work in fundamentally different ways. Understanding the difference can help you make smarter decisions that aligns with your goals, your family dynamics, and your international exposure. In Dubai, inheritance is governed by the Sharia law by default. This means your assets may not be distributed according to your personal wishes unless you take active steps. For non Muslim residents, the government does offer alternatives. But many people don't realize just how different the outcome can be depending on whether you use a will or a trust structure. And that is what we are going to discuss in detail in this video today. Before we start, my name is Shiraz Wahid and I'm the co-founder at Leopardus Wealth, where we have helped many of our clients and families with trust, foundation, and other asset protection strategies in Dubai. If you would like my help in doing the same, you can apply for a free and customized asset protection plan by clicking the link in the description below. Now, coming back to the topic, a will is a document that states who should receive your assets after your death. In Dubai, this usually means registering a will through DIFC. This gives you access to common law framework, which can be reassuring if you come from jurisdictions like UK, Canada, or Australia. Once the will is approved, your assets are distributed according to your instructions. It seems simple enough, but there are more things to consider. While a will lets you control who gets what, it does not avoid probate. That's the legal process your beneficiaries must go through before any assets are transferred. Probate takes time, it can be contested, and your assets may be frozen during that period. In the meantime, your family might not have access to funds they need. This is where trust becomes more powerful. A trust is not just a document, it's a structure that holds your assets now and after you pass away. When you create a trust, you transfer ownership of your assets to a trustee who manages them on behalf of your beneficiaries. Because the trust owns assets, not you, there is no need for the probate process. The trust continues to operate without interruption, giving your family continuity and privacy. This difference in timing is crucial. With a will, everything is triggered after death. With a trust, the plan is already live. For example, if you are running a business and wanted to keep functioning smoothly without delays or legal challenges, placing it inside a trust ensures that there is no disruption if something happens to you. Another benefit is asset protection. A trust can shield assets from legal claims, creditors, or even family disputes. Wills do not offer this kind of protection. Once probate starts, your estate is exposed to challenges, including possible claims from estranged relatives and business partners. There is also the question of privacy. Wills eventually become public documents during probate. Trusts, on the other hand, are private by nature. That discretion can be essential for high net worth families with complex relationships or global exposure. But trusts are not just about avoiding problems. They can also be used for structuring wealth across generations. You can include rules about how funds are used, at what age beneficiaries gain control, and even align distributions with life milestones or responsibilities. Wills, on the other hand, don't give you that level of control. You might be wondering that if trusts are so powerful, why do people still use wills? Well, the answer often comes down to simplicity and cost. Drafting and registering a will is faster and cheaper. If your situation is straightforward, say you own a bank account, a car, and some personal belongings, a will may be sufficient. But if you own real estate, a business, global assets, or have dependents with special needs, a trust is often a better choice. That's especially true in Dubai, where legal systems overlap and families are often split across multiple countries. Now, let's take a practical example. Suppose you're an expat living in Dubai with properties in both your home country and in the UAE. If you rely only on a Dubai registered will, your assets in the UAE will be covered, but not necessarily those abroad. That means your estate could be subject to different legal systems, creating delays and extra cost. With a trust, you can consolidate global assets into a single structure. You get one trustee, one plan, and one line of succession. Another example would be of an expat entrepreneur who owns shares in multiple companies, including startups. If those shares are held personally, they become part of the probate process. But if they are transferred into a trust, there is no delay in succession. The trust simply continues holding those shares, managed by a trustee you've already chosen. What if you already have a will in your home country? Many clients do, but the reality is foreign wills may not always be enforceable in Dubai. The local courts might not accept them, especially if they conflict with public order or involve Sharia inheritance rules. That's why it's usually better to have a locally compliant solution. The good news is that you don't always have to choose just one option. In many cases, we recommend using both: a trust for major assets and a will for personal items or specific instructions. The will can complement the trust by covering anything that falls outside the structure, but the core plan remains stable because it's already active. It's also worth mentioning that DIFC and ADGM both offer robust legal framework for establishing trust with international recognition. These are common law jurisdictions that operate independently from mainland courts, which gives you more control and predictability. You can appoint a professional trustee or a corporate trustee, and even specify succession plans across multiple generations. There are also tax considerations. In some jurisdictions, passing assets through a will may trigger estate taxes or capital gains. A properly structured trust may help reduce or defer these liabilities. Of course, this depends on your country of residence, citizenship, and how your trust is set up. But it's another reason why trusts tend to be the preferred tool for international families. One concern that some clients raise is control. They worry that putting assets into a trust means losing access. But that's not always the case. With the right setup, you can be both a founder and a beneficiary, and appoint trusted professionals to act according to your wishes. So, when should you use a will and when should you use a trust? You can use a will when your assets base is limited, your family structure is simple, and your priorities are clarity and speed. Use a trust when you need control, protection, continuity, or you have cross border assets and beneficiaries. Each tool has a role. What matters is designing the right structure for your specific needs, not just for today, but for the future generations who will benefit from it.